Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today I am back with another regulation, that is the SEBI Stock Exchange and Clearing Corporation Regulation 2018. We have been doing the security laws and today we are starting with this regulation. Please start preparing for phase 2 from now only. I have been telling you this from day 1. You have to start preparing for phase 2 examination from now only. So that is why we are dealing with the security laws first. Before I start, I would like to tell you that EduTap is coming up with test series for both the phases, phase 1 and phase 2. It will include chapter-wise tests, sectional tests and full-length tests. It will be very helpful for you to prepare for the examination and for the revision as well. Also, we are coming up with a live crash course for both the phases of this examination, phase 1 and phase 2. It will include live classes. It will have 60 plus live sessions. Test series that I've mentioned earlier, that is included in this live crash course, and it will also provide you one-on-one mentor support. It will be a huge help for your preparation. To avail the offer, check the link in the description below. Let's start. Question number 1. Which of the following is true? Securities Contract Regulation, Stock Exchange and Clearing Corporation regulations were formulated in the year 2017. Securities Contract Regulation, Stock Exchange and Clearing Corporation regulations contain 52 regulations. Only the option 2 is correct. The regulations were formulated in the year 2018. So the answer is option C, that is only 2. Securities Contract Regulation, Stock Exchange and Clearing Corporation regulation were formulated in the year 2018. And it is true that they have 52 regulations. Right? Question number 2. The application for seeking recognition of clearing corporation shall be made in which of specifically framed form for clearing corporation. So if someone is seeking recognition for clearing corporation, which form will be used? The answer is option D, that is form A. Where it is written? It is written in the regulation 4. Subject to the compliance with the provisions of the Act, rules and these regulations, an application for recognition as a stock exchange. Now the question was recognition of the clearing corporation. This regulation mentions for both the stock exchange and the clearing corporation. So first of all, an application for the recognition as a stock exchange shall be submitted in the board in Form A as prescribed under Rule 3. Form A as prescribed under Rule 3 of the rules, and an application for the recognition as a clearing corporation. So if it is the case of clearing corporation, shall be submitted to the board in Form A as specified in Schedule 1 of these regulations. Right? So the answer is Form A, that is option D. Question number 3. An applicant seeking recognition of a stock exchange shall comply with which of the following conditions? So if someone is seeking recognition as a stock exchange, what will it comply with? The options are: the applicant should have the necessary infrastructure for orderly execution of trade, adequate investor grievances redressal mechanism and arbitration mechanism. The applicant has adequate investor protection fund and investor service fund, adequate infrastructure to list securities for trading on its platform, or all. The answer is all of the above. Let's read the explanation. Under Regulation 7, Sub-Regulation 3, an applicant seeking recognition as a stock exchange shall, in addition to the conditions as specified in Sub-Regulation 1 and 2, comply with the following conditions, namely, what are the conditions? The applicant has the necessary infrastructure for orderly execution of trades. Right? They have the necessary infrastructure to execute the orderly trades. The applicant has an online screen-based trading system. The applicant has an online surveillance capability which monitors positions, prices and volumes in real time so as to ensure the market integrity. The applicant has adequate infrastructure to list securities for trading on its platform wherever applicable. The applicant has necessary capacity to have a nationwide network of trading members and has adequate facility to admit and regulate its members. The applicant has made necessary arrangements to establish connectivity with its trading members and clearing corporation. The applicant has adequate investor protection fund and investor service fund. The applicant has adequate investor grievances redressal mechanism and arbitration mechanism to resolve disputes arising out of trades and its settlements. The applicant has the facility to disseminate information about trades, quantities and quotes in real time, at least 2 information vending networks which are accessible to investors in the country. The applicant has adequate system capacity supported by a business continuity plan, including a disaster recovery site. The applicant has in its employment sufficient number of persons having adequate professional and other relevant experience. The business feasibility plan has been appraised by a reputed agency having expertise in such stock markets, and lastly any other condition as may be specified by board. So if he is seeking recognition as a stock exchange, all of these have to be met with. So the answer was option E, that is all of the above. All of these options are mentioned in regulation 7. Question number 4. The recognition granted to the clearing corporation shall be in which of the following form? Now that the recognition has been granted, it will be in which form? So it will be in form B. So it will be in form B. Grant of recognition regulation 9. The board may, after considering the application under regulation 4 and on being satisfied that the applicant has complied with the conditions laid down in regulation 7 and it's eligible to act as a recognized stock exchange or a recognized clearing corporation. So this is for both, as the case may be, grant recognition to the applicant in terms of section 4 of the Act in the interest of the securities market. 2. The recognition granted to the stock exchange under subregulation 1 shall be in form B of the rules. So in case of stock exchange, it will be form B. So in case of stock exchange, it is form B of the rules, and the recognition granted to a clearing corporation shall be in form B of schedule 1. It will be form B of schedule 1 of these regulations. The recognized stock exchange and the recognized clearing corporation shall comply with such other conditions, including those with regard to the nature of the securities to be dealt with, as may be imposed by the board from time to time. So as the board may impose other conditions also, the recognized stock exchange and the clearing corporation have to comply with those also. So the answer was option B. This is form B. Form B in case of grant of recognition, right? Question number 5. The recognition granted to a clearing corporation, what period of time? So what is the period that the recognition is granted? Is it permanent? At least 1 year if temporary, at least 2 years if temporary, either A or B, either A or C. The correct answer is either A or B, that is permanent, or it has to be at least for 1 year. Let's read the explanation. The period of recognition granted to a stock exchange shall be as per the rule 6 of the rules. So in case of stock exchange, it will be as per the rule 6 of the rules. And in case of the clearing corporation, unless granted on a permanent basis. So either it can be permanent or shall be for such period not less than 1 year. So at least 1 year. It cannot be less than 1 year as may be specified by the board. So it can be permanent or it cannot be less than 1 year. Right? This is in case of clearing corporation. Question number 6. Consider the following information about withdrawal of recognition of clearing corporation. Regulation 11 of Securities Contract Regulation Stock Exchange and Clearing Corporation 2018 mentions about it. Form C is to be used for the withdrawal of recognition to the clearing corporation. Which one is correct? The answer is B, that is none. None of them is correct. It is the regulation 30. The recognition granted to a stock exchange or a clearing corporation may be withdrawn in the manner provided under section 5 of the Act. So it is not 11, it is 13, and it talks about a form also, form C, but no such form has been prescribed in the regulation. Right? So question number 7 now. Guarantee of settlement of trades is responsibility of whom? The options are SEBI, clearing corporation, stock exchange, all of the above, A and C only. The answer is clearing corporation. So guarantee of settlement of trades is the responsibility of the clearing corporation. every recognized clearing corporation shall establish and maintain a fund by whatever name called for each segment to guarantee the settlement of trades executed in respective segment. To guarantee the settlement of trades. To guarantee the settlements of trades executed in respective segments of recognized stock exchange. Right? So the answer is B as per Regulation 37. Question number 8. Which of the following can acquire up to 15% shareholdings in a clearing corporation? So in case of clearing corporation, who can acquire 15% of the shareholdings? 15% of the shareholdings. A foreign depository, a foreign bilateral or multilateral financial institution approved by the central government, a foreign stock exchange, a foreign insurance company, all. The answer is E, all of the above. Let's read the explanation. No person resident outside India shall directly or indirectly, either individually or together with the persons acting in concert, acquire or hold more than 5% of the paid up equity share capital in a recognized clearing corporation. But provided, what does the proviso say? A foreign stock exchange, a foreign depository, a foreign banking company, a foreign insurance company, a foreign commodity derivatives exchange, and a bilateral or a multilateral financial institution approved by the central government may acquire or hold either directly or indirectly, either individually or together with persons acting in concert up to 15% of the paid up equity share capital of a recognized clearing corporation. Right? So they can hold up to 15% of the equity share capital. For the purposes of this proviso, the persons referred to in clause A to F shall mean persons recognized incorporated outside India. So as all of these options were mentioned in the regulation, that is why the answer is option E. Question number 9. Which of the below is not a part of oversight committee? So which of these is not a part of oversight committee? Standing Committee on Technology, Regulatory Oversight Committee, Risk Management Committee, Investor Protection Committee. The answer is Investor Protection Committee. The Investor Protection Committee is not a member of the Oversight Committee. Let's read it. Oversight committees comprising Standing Committee of Technology. B was the Advisory Committee, but now it has been repealed. Regulatory Oversight Committee and Risk Management Committee. Right? Let's move on to question number 10. Which of these statements states truth about the compliance officer? The compliance officer shall independently report to the board any non-compliance of any provision within 10 days. Every recognized stock exchange and recognized clearing corporation shall appoint a compliance officer who shall be responsible for monitoring the compliances of this Act, the Securities Board Exchange of India Act 1992 rules, regulations or directions issued thereunder, and for the redressal of investors' grievances. The answer is option number C. Only the second part is correct. The part 1 is not correct. Why is it is not correct? Let's find out. If we read Regulation 30, the compliance officer shall immediately, it says immediately, not within 10 days, the compliance officer shall immediately and independently report to the board any non-compliance of any provision stated in sub-regulation 1 observed by him. So he has to report it immediately, not 10 days, he has to report it immediately. So the answer was only 2. The second one is correct. Question number 11. Penalties levied by the recognized stock exchange or recognized clearing corporation shall be credited to which fund? Is it contribution to the settlement guarantee fund, investor protection fund, grievance redressal fund, or investor compensation fund? The answer is investor protection fund. So any penalties levied by the recognized stock exchange or clearing corporation, they shall be credited into the investor protection fund. Option B. If we read Regulation 32, penalties levied by recognized stock exchange or recognized clearing corporation shall be credited to its investor protection fund. To its investor protection fund or a fund as specified in Regulation 37 as the case may be. So the answer is investor protection fund. Next question. Question number 12. What directions SEBI can issue in public interest under Securities Contract Regulation, Exchange and Clearing Corporation Regulation 2018? Debarring a recognized stock exchange or recognized clearing corporation from introducing new products and services and restricting its existing activities, products and services. So can it debar it from doing that? Imposing such monetary penalty as may be determined by the board on the recognition stock exchange or recognized clearing corporation, directors, committee member, key management personnel, employees of any other person associated with the recognized stock exchange or recognized clearing corporation. So imposing such monetary penalties, can SEBI do it? Restricting any such person to attend meetings or otherwise participate or involve themselves in functioning of the recognized stock exchange and recognized clearing corporation, or D, all of the above. The answer is option D, all of the above. The SEBI can issue directions in any of these matters. The answer is option D. SEBI can issue directions in all of these matters. Question number 14. The combined holding of all persons resident outside India in the paid up equity share capital of a recognized stock exchange shall not exceed 41%, 51%, 49% or 59%. The answer is 49%. If we read Regulation 17, Sub-Regulation 4, subject to the limits and otherwise prescribed by the central government from time to time, the combined holding of all the persons resident outside India in the paid up equity share capital of a recognized stock exchange shall not exceed at any time 49%. It will not exceed 49% of its total paid up equity share capital. Right? So the answer is option C, 49%. Last question, question number 15. Which of the following is false regarding listing of the securities of stock exchange? A recognized stock exchange shall not list any securities of its associates. Stock exchange must have completed 3 years of operations in continuous manner. The securities of a recognized clearing corporation shall not be listed on any stock exchange. Approval of central government must be taken before securities of the stock exchange are listed. The answer is option number D. Approval of central government must be taken before the securities of the stock exchange are listed. No, but the approval of SEBI is to be taken. Let's read it. Regulation 45. Subject to the provisions of the applicable laws in force, a recognized stock exchange may apply for listing of its securities on any recognized stock exchange other than itself and its associates and its associate stock exchange if it is compliant with the provisions of these regulations, particularly those relating to the ownership and governance, if it has completed 3 years of continuous trading operations. So it is continuous 3 years. Trading operations immediately preceding the date of the application of the listing. Immediately preceding the date of the application. That is, they have completed 3 years continuous immediately preceding the application. And it has obtained approval of the board. So it has to take the approval of the board and not the central government. Provided the board may specify such conditions as it may deem fit in the interest of the securities market, including those in relation to the transfer of shares held by the person. So the board can specify such conditions as it deem fit. That is why the answer was option D, not the central government but the SEBI. Now a bonus question for you, that is question for achievers. Regulation 25 of this Regulation 2018 states conditions of appointment of managing directors. In this context, consider the following statements. The appointment, renewal of appointment and termination of service of managing director of SE or CC shall be subject to the prior approval of the board. The appointment of the managing director shall be for a term not exceeding 5 years. Maximum of 2 terms of 5 years of each are allowed, subject to the maximum age limit of 75 years. If a person holds any position concurrently in the subsidiary of a depository or in any other entity associated with the depository, cannot be appointed as a managing director. So you have to take out the false option. Which of these is false? You have to comment the right answer below. So that was all for today. I hope this was a helpful session for you. For more such videos, please subscribe to the channel EduTap. Thank you.